Hey guys, Marilyn Manson is finally going to trial in one of the cases against him. Or is he? It's never too late to have another delay in a case, but they are planning to go to trial next month. And so the parties are engaged in a lot of motion practice that you see just before trial, including motions in limine, which is to exclude evidence generally, also asking the court to issue evidence sanctions. Here, specifically, the plaintiff wants to have Manson banned from testifying in his own trial and also have some of the witnesses he said could support his side of the case banned from testifying at trial. That's obviously pretty extreme. So let's look at least at some of the documents that are out there, and some of it's still under seal. I probably have missed some. There's been so much, but I think we'll get the gist of what's going on in this, hopefully, at least. So let's make this bigger and take a look at it. All right, so this is going to some degree, surround the issue of the Fifth Amendment, okay, to the United States Constitution. And part of that says you can't be compelled to incriminate yourself. So you'll see that invoked in, well, sometimes before trial, but also at trial. The defendant doesn't testify and the state can't make them testify. You can also do it in civil cases, and maybe you know that, maybe you don't, because you can't be compelled to testify there either. However, it can have a lot different consequences depending on whether you're doing it in criminal court or a civil case. Because in civil case, the refusal to testify can sometimes lead to issues for the defendant. It can be a risk situation, because if you decide at the last minute, well, I think I do want to testify, in criminal court, okay, but in civil court, that can be an issue because you've deprived the other civil party, not the state, the civil party, the ability to do discovery, to find out what your testimony is ahead of time, while they've had the ability to depose the plaintiff in the case. So sometimes the court will say, well, no, you waited too long. I'm not going to let you change your mind at the last second in the civil case because you're just gaming the system here, right? So that's a risk if you're invoking the Fifth and you want to change it at the last minute. Basically, the idea is, yes, you can obviously exercise this constitutional right, but in a civil context, you can't do it to game the system, either to create unnecessary undue delay or to otherwise prejudice the plaintiff unfairly. And of course, that's what's being said in this case, but is it really what is happening? And it's only part of what's going on in this case. But that's just to kind of set the stage of it. And let me mention something else too that can matter. In a criminal case, if you take the Fifth and you don't testify, the court cannot tell the jury, well, if he didn't do it, he would have been on a stand telling you, right? There can't be a negative inference given about the fact that you decided not to testify. In the state, the prosecution cannot get up there and say the same thing in a closing argument, that you've heard from everybody but the defendant over there. If that defendant had something to tell you why he didn't do it, he'd have been up on the stand. So they can't do that. The conviction would be thrown out. But in many jurisdictions, I'm not sure, I haven't counted, I would say most, but I'm not sure of that. That's not true in a civil context. And so look down at the bottom right of my quotes here. In a civil case, adverse inferences may be drawn against a party who asserts the Fifth Amendment and remains silent. The Fifth Amendment does not forbid adverse inferences against parties to civil actions when they refuse to testify in response to evidence offered against them. So that's how it is here where I'm at in North Carolina, but I had to look it up. In California, it is not the same. So you see the evidence code up there that you can't do that. So they say you cannot raise a negative inference if somebody decides not to testify based on the Fifth Amendment. So depending on where you are, your actions in a civil case can have far different consequences. That's why I always say, it depends is the lawyer words, right? And it does depend a lot in terms of what jurisdiction you're in, what the evidence rules are, and what's happening and stuff. Well, at any rate, if Manson is deciding to waive his Fifth Amendment privilege, this won't matter anyway. So, but it could have mattered if he were going to remain silent, and it would have been potential benefit to him in California, as say compared to here or many other courts. All right, so we got the Fifth Amendment out of the way, right? He can claim it. That's fine. What the plaintiff is saying is, but what he can't do is abandon it on the eve of trial, having prevented me from getting lots of discovery, and then use that to sandbag me. That's going to be the argument that she's got. Let's take a look at it. So here's the motion for evidence sanctions are part of it. For 2 years, Manson did not respond to discovery in a substantive way, invoked his Fifth Amendment right to avoid providing information multiple times. Then 2 years later, 12 days before discovery cutoff, he amends his discovery responses and revokes his Fifth Amendment privilege and answers new questions. And here they say that discloses 11 new witnesses and provide documents that he previously swore under penalty of perjury didn't exist. And all of this information was available to him when he originally responded. So this is gamesmanship and sandbagging and 11th hour. So you're throwing all the words there at a judge of why this is a bad thing. Defendant spent nearly 2 years hiding behind the shield of the Fifth Amendment. He refused to participate in discovery under the guise of the Fifth Amendment. It's not really under the guise of it. I mean, that's a right? He shouldn't be rewarded for handicapping the plaintiff at trial. If this were permitted, every civil defendant in every single case involving criminal acts could plead the Fifth to avoid disclosing information relevant to the case and then simply waive that privilege at the last moment. And that's not exactly true, because in theory, what you should do if you're the plaintiff in that case, in that situation, and you think somebody is inappropriately claiming the Fifth, is you can press them on it. You bring it to a resolution. Either you bring them to a deposition and they refuse to answer questions, or you send this discovery and they refuse. And if you think it's outside the scope of something that can incriminate them, you can bring that before a judge, and the judge can handle it. And the judge also can sanction the person if they're doing things inappropriately or sandbagging on discovery and such beyond what their rights allow. Look at what happened to Alex Jones. Whether you think it was right or not what happened to him, what did happen to him was based on the court saying that he abused discovery. They struck his answer and defaulted him. That's how serious this can get. Again, that's not a comment on whether it was warranted there or not. It's a comment on the power of the court. So the plaintiff here says the timing is a severe abuse of the discovery process and an unveiled attempt to severely prejudice plaintiff's trial strategy and force a continuance of the trial, which this court has already denied twice. So that's basically what the plaintiff is setting out here. And I got the little summary here that the plaintiff is not arguing that you can't plead the Fifth in a civil case, because that obviously you can. But what the plaintiff is basically saying is you can't use that to game the case. You can't withhold evidence for surprise and prejudice against the plaintiff, and then at the last second change your mind and expect to be able to just come into court and do whatever you want. 12 days left in discovery. And, okay, so that makes sense. The argument makes sense. Now, that's not to say it's a correct argument or the better argument, because we haven't gone over Manson's side yet. But you see the point here, right? There would definitely be some circumstances where this would be unfair in a civil court to change your mind at the last second. But not every circumstance is going to be like that, or else why would you have the ability to waive your privilege later? And we will see how Manson responds. But basically, the plaintiff wants late documents excluded. And this is interesting because we just talked about the Fifth Amendment reason, right? She's saying that he didn't turn this stuff over until the last second. But there's also another issue, which is, I think some of the discovery, Manson said, I don't have this stuff. Then later on, Manson says we need to delay the case because the investigating authorities on the criminal side have all my stuff. I can't get to it. And then just before, they're getting close to trial, he amends his discovery responses and says, yeah, okay, there are some videos and messages and things like that. So the plaintiff sees shenanigans in this. Like, first you tell us the stuff doesn't exist. Then you tell us the sheriff has it, but how can the sheriff have something that's responsive if it doesn't exist? Then you tell us, well, okay, not only is it not true that I don't have it, and not only is it not true that the sheriff has all of it, but actually I do have some of it. So that's what she's saying. Now, you should if you want to really make an issue out of that, you need to call Manson to a deposition and say, well, what were the circumstances of you just finding it? Because, you can supplement discovery. Sometimes you do find things later. And of course, if you don't like Manson, you're going to assume he was hiding them the whole time to wait to surprise this person. And if you do like Manson, you're going to say, well, he probably just found it. And that's all supposition, unless you go to a deposition and put Manson under oath and say, well, how did you find this stuff? And if you wanted to sanction Manson by saying, I want to keep this stuff out or whatever, I think you need to do that. And you're going to have to show the judge why the supplemental discovery was inappropriate, because it possibly is, and it's possibly not. And I don't have any answers to that, and I haven't seen anything filed that would show that one way or the other. So without showing that, in theory, he should probably be able to use this stuff. But again, the plaintiff can make an argument against this. Maybe he has under seal or something. I don't know, but I didn't see it. But the late witnesses are another issue. And this is asserted that Manson didn't tell some of these witnesses. It was 11, and I think they changed it to 5 based on the Fifth Amendment. Now he says, hey, here's some people who can support my case. And then also Manson himself wants to now testify, but she says he was asserting his privilege. Now, what I wasn't sure of from what I saw is whether he asserted this privilege in his discovery. Did they try and notice his deposition and get him to sit down in front of a court reporter and say, I'm taking the Fifth on all this stuff? I mean, I don't know how they exactly practice out there, but here I think that's what we would have done if we wanted to be able to lock this person in and say you can't testify later. Then we would have gone to the trouble of getting them on the record for all the scope of testimony that we wanted from them, saying I'm taking the fifth on this, right? Because then you could tell the judge, look, we tried, we did everything the discovery allowed. This person wouldn't let us do it. I don't know if that happened there or not, or whether it has to. But if all you did was send interrogatories, the court may see that as a little bit more favorable to Manson, that you never brought this motion before to try and limit this or force the issue or something like that. So we'll see. And I am saying that because of how I read this case law that gets cited in this case, and we'll see in a few minutes. So Manson responds, right? There really wasn't any point in going over the plaintiff side of things until you get Manson's response, so you can see both. Because obviously on social media, if you're a Manson fan, I saw, well, she's totally wrong and everything. Well, not really, not from a premise of an argument situation. It really depends on what Manson did do here, because, it is possible to game the system in such a way that you're going to get sanctioned by the court. But I wanted to see what Manson's real response was to it, to see whether he had a good counter argument to what the plaintiff was saying. I think he does. So he says, look, we always reserve the right to waive privilege later, and the plaintiff never challenged that by bringing the issue to the court. Okay, so they were on notice that I may decide later to waive the challenge, and only now when I do it is the plaintiff coming forward. And that's going to matter when you take this into the context of the timing of things and what the possible remedies are. Now, Manson also says, listen, the trial could be delayed. Okay. I mean, we asked for it to be delayed, Manson says, and the plaintiff actually stipulated or was agreeing to that until they found out that the next court date was like 1,000 years from now, which isn't Manson's fault. And it's not the Jane Doe's fault either, right? The court system backed up, and it's amazing they can't get them on the docket faster than they said. But I think when Jane Doe heard that, the attorneys on that side said, and we're not going to stipulate to it. That's just too long. But Manson has a good point that if the plaintiff feels prejudiced at this point and that she can't go to trial fairly, then an answer could be another delay rather than I'm banning Manson out of the game. And I think to get past that, you have to show that Manson set this up so that this really would happen, like there would be no way to deal with what he's doing here. And in that case, the court might want to sanction him more. But if not, the court shouldn't jump to the most severe sanction. There has not been, to my knowledge, a motion to compel or any kind of discovery motion to try and force this issue earlier. This would be the court's first attempt to address it. And you usually don't drop a nuclear bomb on the other side for a discovery sanction at the first motion. For example, even in the Jones cases, I think there were other sanctions motions ahead of time before the ultimate sanction was dropped. Now, Manson also says, listen, I'm also having to adapt to new claims she's making. Yeah, I was standing on the privilege earlier, but she keeps adding things. And so that changes how we're going to address the case as well. For example, he says, I need some of these witnesses to rebut what she's now saying, that she was locked in the soundproof room. And Manson says, I have people who will say that didn't exist there. And it's certainly not a locked soundproof room. And she didn't move in like she said she did. So he's saying the increased scope of memories that the plaintiff is saying she has causes him to have to adjust how he's going to address the case. And that is a logical point. And I think in my last bullet here, you can't go to the most severe sanction where it was never forced. So we already talked about that. So those are a couple of good points by Manson. So we got good logical points, but what's the court going to do? They're also going to try and look at what the law is, not just, well, hey, I think this or I think that. You, in theory, want a court to look at what the law is. And Manson brings some heat on that end. A little bit surprising. I'm sure not every jurisdiction is like this, but it is still a case that I think it is in his favor, as he says it is. So he says, contrary to plaintiff's arguments, Warner's waiver of his Fifth Amendment rights did not come too late. He gave her more than 1 month before the Court of Appeals has said, okay, he gave her more than 1 month. Let me start this over again because they're kind of quoting a case while they're talking about their own case. He gave her 1 month more notice than the Court of Appeals has said would be sufficient in this situation to avoid unfair prejudice and surprise to an opposing party. And he quotes this case, Fuller versus Superior Court, saying, as a hypothetical, I think in that situation, the deadline for waiving the Fifth Amendment privilege could be set as late, for instance, as 10 days before trial. So I think the idea there was that somebody was trying to claim the Fifth, or they were claiming the Fifth, and the plaintiff was upset about it and trying to get an issue in front of the court, but they hadn't noticed the deposition yet or something like that. So the Court of Appeals, in addressing it, says, listen, one of the lower sanctions you could do is say, okay, if you stand on this appeal, I'm going to put a firm deadline. And if you don't decide to waive it before more than, say, 10 days before trial, or 30, or whatever the trial court does, if you pass that Rubicon, I'm not going to let you change your mind after that. And again, that's a lesser form of a sanction, right? So the court's, in that case, is not saying, okay, you can't testify. They're saying that the court could put an order in place that sets out the expectations of the party clearly. So if the guy wants to stand on his Fifth Amendment privilege and knows if I wait until 10 days before trial, I can't change my mind after that in this civil case, that seems fair. But because they made that comment, and there's not too much law on this, Manson's team is saying that the Court of Appeals has already said that an order 10 days before trial would withstand muster, and we gave her more than 40 days notice. So we're more than 1 month earlier than the Court of Appeals has said, okay. I don't know that every jurisdiction would say 10 days is enough notice to a party, but Manson is correct that the Court of Appeals said what he's quoting here. So he's got a good point. Applying the principles from other cases where defendants have faced the same dilemma of choosing the fifth and fully defending a civil action, the plaintiff cannot show prejudice because Warner notified her of his waiver 13 days before discovery closed, 41 days before trial, and offered his deposition, which he had scheduled and will take before these motions are heard. So, what he says in his deposition could matter to some of these things, but I think that's good points for Manson, as well as the idea that if you suddenly find that you can't prosecute your case because of this, then a delay would also be another answer if the court doesn't think there's sufficient time at this point. And then you could put these deadlines in place and stuff like that. So you got to weigh that against the idea that the alternative is what the plaintiff is asking for, which is, do not let him testify in his own defense at his trial, and don't let these newly noticed witnesses testify, which is a pretty severe sanction. And asking the court to go straight to that, that's a tall ask under the law, I think, and maybe particularly under California law. So Manson also says, listen, these witnesses, one of the reasons you're hearing that we want to call them now is they have information to rebut your new claims, like being locked in the soundproof room. And also, guess what? These aren't witnesses that came out of the blue that no one's ever heard of before. Like, these aren't a surprise to the plaintiff. It involves his personal assistant, bandmates, the manager, and some of those people are even mentioned in the suit. So if you didn't want to go out and take their discovery earlier, well, you knew that they might say things positive to me, right? I mean, how did you know they wouldn't if you didn't bother to do the discovery? These aren't secret people. And the fact that they could potentially come up as witnesses in the case, it couldn't possibly be a big surprise to you, is what he's saying. And, if they aren't surprised people, I think there's some merit to that. Again, not because I'm saying that the plaintiff should have to go to trial under surprise from Manson, and neither is Manson. Manson is saying, if you feel that way, we can get one more delay in the case. You can do the rest of the discovery you want, then we go to trial. So Manson's offering that middle ground there that I think the cases support. All right, let's get off of that and talk about some of the other motions in limine that I saw. And one is over the famous groupie video. And Manson says he wants the video, and I think he's the one saying it's 44 minutes, excluded. Well, it's interesting there because I guess that means that the plaintiff has it either through discovery or some other mechanism, because he wants to exclude her from showing it, and she can't show it if she doesn't have it either gotten through discovery or some other method. So that maybe I'm the only person at this point who hasn't seen this video. Originally, it was a theory was no one's seen this video, but it sure seems like that list is growing. Manson says, listen, the only point of this video is to prejudice the jury. She's not in it. It doesn't do anything to substantiate her claims. It's not relevant to proving her claims. Now, I know she probably haven't read it, but a counter argument to that, which is maybe that was a way he kept her in fear or showed some kind of consistent pattern of behavior. There would be lots of good arguments for her to say why it does matter. But it clearly, if you're her side, you want that in front of the jury if it's anything like what they say it is, because in theory, you do want to prejudice the jury, right? You want to prove your claims, but yeah, you want that jury to think he's a bad actor. So it can be both purposes that you want it in there for. But Manson says, if you are going to let it in, then we want to call Paula Weiss, which the plaintiff says, do not allow him to call her. But I think Manson I can't say which way the court should go on this video. I don't know. I'm the one who hasn't seen it. So, however, if they are going to show it, I think it's fair to allow Manson to call Paula Weiss to rebut what the implications are of the video, because he says she can come in and say, I was a paid actress. It was all fake. Nothing was bothering me in it. Had a good time doing it. Hung out after it was over. And so if the point of the video is to show that, he's a terrible bad actor or something like that, it seems fair to rebut that with a witness who, or actually the central person in the thing, allegedly, to say it wasn't those things. It was, it was just a movie we were making. And yeah, you may not like it, or you might like it, but that's all it was. It wasn't anything other than that. She's going to say, he says. Well, why shouldn't he be allowed to call her to rebut that if that's the implication from the video? It kind of makes sense, but I'm a little bit in the dark on this because I don't really know what the plaintiff is claiming this video will do. But if part of it would be, prejudice to the jury, or, which I think that's clear, that it would be that, assuming the video is like it says, and depending on how it's portrayed, the relevance of it in the trial, I think his argument has merit that he should be able to rebut the implications of that video. Family Feud. There's also a motion in limine that the plaintiff wants Manson's wife excluded. She shouldn't be allowed to testify. And he says, well, she should, because she knows somehow the living arrangements were, and also she can go against some of the bad character evidence that you want to put in. And then there's also a motion that Manson wants the plaintiff's sibling excluded, and that's under seal 2, I think. So you can't see a lot of this stuff. So I don't have any idea what that person would say. And so I can't say whether Manson's right or wrong about that with any background to even make an opinion on it. But, it's not atypical to see motions like this before trial from both sides. I think that's fine. A plaintiff by any other name. Manson wants the plaintiff to use her real name at trial. And that's an interesting situation, I think, because let's step out of her case for a moment and let's go to a couple other ones like Smithline and also Bianco. Now, they filed in federal court under their own names, but there were protective orders entered so that a lot of the things in the case were filed under seal, and discovery was exchanged under seal or confidentially pursuant to the order. And that's not atypical for that to happen. And so the idea is, well, what about the public's right to know and stuff like that? So at the beginning of a case, I'm talking about discovering information about the people involved in it, the witnesses and stuff. The public's right to know is kind of at its lowest at that point, because this is just discovery. The court's not doing anything to anybody and all that. But as the case gets closer to trial and disposition, or a dispositive motion, one that will on the merits actually decide the case, but let's stick with trial, that's when the public's right to know becomes the highest, and the court should have a higher level of scrutiny for holding anything confidential. Not that it can't be, but it's kind of like, well, at the beginning of the case, the court can go real easy giving you a confidentiality order, because not every person out in the public has a right to know people's private business just because a suit is filed, with some allegations in it. And then all these witnesses' personal information is out there, and everybody's life background, because just, depositions can be quite broad. The exchange of documents can be quite broad. That makes sense. But at trial, the public has more of a right to know, its highest right at that point. How is the court handling cases like this? And is this fair or not? The idea that we shouldn't have a secret judicial system becomes pretty important. I mean, you can still hold some things confidential, like you're not going to broadcast a child testifying in some horrifying case, or show pictures that are, that are private, and in terms of horrible things that happen to victims and stuff like that. Maybe you don't get to see all that if you're a member of the public. The court controls the situation, but in theory, it should be open court at that point. And that to me carries back to this main point here of a plaintiff by any other name, because this plaintiff filed in an anonymous fashion, and Manson is saying now at trial, she should have to use her real name. And it's not quite the same as these confidentiality orders. It's a little different issue, because you could, I suppose, go through the whole trial and not know the person's name. You're just going to use this Jane Doe or whatever. But that seems tricky, because you're going to be asking all the witnesses to make sure they don't say this person's real name, and what happens if they accidentally do, and oh my God, the name gets out and stuff like that. So I think that's a little, I don't know how they're going to resolve this, but I guess what I would say, civil cases are generally about money. And I think if you sue somebody for money, when you get to court, you probably should be using your own name. For example, in theory, we judge these neutrally until the trial. So we're not going to say Manson did it or didn't do it. And therefore, they're kind of on equal footing. But he suffers consequences because he is named as the defendant in the case. He has suffered a lot of consequences negatively, not just because of being named in suits, but certainly the media picks up on that and points that out. Yet if you're on the other side of the suit, you don't have to say what your name is. that seems pretty unfair, and more unfair as time goes by and you're actually going to show up to court to ask this money judgment be entered against him, and you don't have your name out there, but he does. Let's say she loses the case. Let's say it was all made up, and I'm not saying that's true, but let's say there is a case like that against him. He can't ever say who did this to him. I mean, that's ridiculous. So, like at some point, that seems unfair to me, I suppose. Now, they tell the court, well, I could be harassed and things like that, and that's fair. That's fair, but it sure seems to me you need to make some real showing of that before you tell all the witnesses at trial and everybody at trial they can't say what this person's name is and stuff, because Manson knows who it is, and that people around Manson know who it is, and I think any serious Manson fan knows who it is. Plus, people who hate Manson a lot know who it is. Who doesn't know who it is, or probably only people not motivated to do any harassment. So at this point, with the case having dragged on so long, I think the identity is probably there anyway. But I don't know how the court's going to resolve that. If I were doing it, I'd be on Manson's side for the most part, I guess. I'm saying for most of the things that we talked about today. I think it's too much on the first action to forbid him from testifying at his own trial and call these witnesses based on his change in posture on the Fifth Amendment, because he might have hoped that the criminal stuff got clearly resolved before this case finally got to trial. It's too much on the first order. If he had been ordered to do it and didn't do it, and been told that if you don't do it by this date, the court will prevent you from testifying, and he went on past that, I think the case law would support that. But I think he's got the better end of that now, even if a delay does suck, because cases take too long to get to trial. And I think that's probably how the court will go with this. Now, on the other hand, this plaintiff by another name, I don't know what the court's going to do. May keep it anonymous or whatever. I kind of don't like that, but it's California, and they can have the rules that they want to have on it, I suppose. But I see Manson's point on that, and I think really in the end it doesn't matter, because probably people who want to know who this is, and if they're curious about it, they've already found it out. Well, that's it for now. Don't be surprised if this case settles. Don't be surprised if this case gets delayed again. Don't be surprised if it goes to trial. Anything can happen. And we'll find out soon on this one, though, because it actually is up for trial. So that's it. And I appreciate you guys stopping by and listening about this case. Talk to you later. Thanks. Bye.